Hello, everybody, and welcome to Common Law Ascent's podcast. We do voice recordings because we have lots of literature that is written by people on the Constitution, and sometimes it's easier to read it on a recorder than actually do a video or type it up. Here I have John Bingley, and he's done extensive research into the Bill of Rights and the Declaration of Rights. He actually went and opened them. They were both sealed. So he's done a really long work here, and I've got it. So I'm going to read some parts of it out, and it's just so long. Basically, so this is for Common Law Ascent, and my name is Danielle. So welcome everybody, and thank you for listening. It says, the introduction, so the principles of, the English Constitution, this is, "Be ye never so high, the law is above you," affirmed Sir Thomas Fuller. This still holds true today and should invariably provide a fundamental constitutional constraint upon Parliament. For although Parliament may make or unmake any law that is not entrenched, it may not, under any circumstances, disobey any law in force. This is the backbone for the argument that is for Britain's sovereign independence to survive the rule of law, and the Constitution must be paramount and immediately restored to their rightful position. Henceforth, therefore, Parliament must be constrained by the will of the people to keep within its bounds, set out in the Bill of Rights and sworn by the Coronation Oath and oaths of allegiance as the servant and not the master of the people. The judiciary are responsible for ensuring that the law of the land is upheld at all times without fear, favour, prejudice or ill will. The English Constitution. Perhaps you are surprised by the heading, but yes, we English do have a written constitution. It is not a single document that you can sit down and read, but a number, such as Magna Carta 1215, the Bill of Rights 1689. The Constitution also consists of much that has been created by statute, such as the Royal Air Force or the Police Force. The frequently quoted mantra that we have no written constitution is highly misleading. Most is written, and most has been settled for centuries. The parts that are unwritten lie within the common law and custom. That does not mean that all common law and custom is unwritten, or that they are not constitutional. The Coronation Oath determines that we shall be governed according to the statute law, the common law, and the custom. This oath is the bedrock upon which the public place their trust, so that they will be governed by a Parliament whose members will abide by this limitation. It is the terms of office for Parliament and may not be constitutionally breached. To undermine the Constitution is treason. The status of the Coronation Oath is both obvious to any logical person or historian and is a matter of formal confirmation. It has been confirmed in correspondence with Jack Straw in 2000 as Home Secretary, who, quite rightly, confirmed it as his constitutional responsibility, and by John Mayer in a parliamentary answer recorded in Hansard as Prime Minister in October 1996. It is obvious that there can be no principle which will lawfully allow a breach of this oath, other than formally to renounce it and start again. The English Constitution is self-preserving and self-protecting against despotism and tyranny or any breach of its principles. The protection is afforded by the written words of the Constitution, the law, and the sworn oaths of those who hold office. They have a duty and they are accountable to it through the courts, whose overriding duty is to uphold the Constitution for the people through the rule of law and the use of juries. That is, the written words of the law, not some opinionated or politicised version. The constitutional power of Parliament to make law. The power of Parliament is exercised by creating and implementing statute law. While this is obvious, it is worth brief analysis as to how lawful power comes about. First, it is recognised that Parliament consists of the three estates of the realm and the monarchy. Originally, the three estates comprised the Lords Spiritual, the Lords Temporal, and the Commons. These were literally the estates of the monarchy. In today's usage, people often refer to the three estates as the monarch, the lords, and the commons, which indicates or infers the people as the owners of the realm. This great change was subtly brought about by freehold and the Glorious Revolution of 1688, which slew the Stuart belief in the divine right of kings. Since the Revolution, all power of the king to suspend or dispense law was outlawed by the Declaration of Rights and the Coronation Oath. The only principled power to make statutes resides in Parliament. Parliament may only make statutes by the formal debate and agreement of its constituent parts, i.e. the Commons, the Lords, and the monarch. The sovereignty or power of Parliament is said to rest with the Crown in Parliament. No individual within Parliament has or may have any power to actually make statute law. It is only by collective, tripartite, formal procedure and agreement that a bill may be enacted to become a statute law. Once enacted, a statute remains in force until such times as it's repealed. In other words, the law applies at all times and during its life said to be of a constant and lasting force. It is also worth noting that the Prime Minister is only an MP. The official state order of precedence is first the monarch, followed by the Archbishop of Canterbury, then the Lord Chancellor as Speaker of the House of Lords, and fourthly the Prime Minister as the leading MP of the House of Commons. The ability to make or unmake statute law is the power of Parliament. Once made, all who serve in Parliament and all Crown servants must obey the law fully at all times, just as any others within its jurisdiction. Crown servants swear oaths of allegiance in order to hold office. In recent times, the monarch has by convention taken the advice of her ministers and granted royal assent when agreement has been reached by the Lords and Commons. It is the duty of those in office to abide by their oaths, individually and collectively, which in turn bind them to obey the statutes, the common law, and the custom. They must govern in order to maintain us in our spiritual and civil rights and properties. These are our fundamental liberties. It is therefore obvious that all officers and ministers whatsoever may not advise the acceptance of any law which breaches any principle of the Coronation Oath, or act against any law which lays down their duty, such as the Bill of Rights. This is the constitutional duty of office supported by law and oath. Any failure to uphold this duty is a mixture of perjury, misfeasance in public office, and possibly treason. Where treason is committed, the penalty may disqualify the guilty from holding any public office forever. This gives rise to the famous rhyme, "Treason never prospers, know the reason if it ever does, none dare call it treason." It is an extremely serious failure and not much considered by today's politicians and civil servants. The public have their remedy through the courts and the independence of the judiciary, who must never become politicised. The law is not a matter of opinion or of policy, but of written words. Judgment must be 100% in accordance with the meaning of the words of the law. Meaning and the words of the law. It is the clear duty of all who govern to uphold the Constitution. At no time has it been otherwise. The law must be applied as it is written, and usually understood, until such time as it is repealed and ceases to be a part of the statute book. The limitation of Parliament. The rule of law is paramount to our Constitution and our justice. Parliament makes only the statute law, and every person within the jurisdiction must live by the golden principle that no man is above the law, both statute and common. How and why should we have a law of the Constitution that binds Parliament? Why should there be any limitations on Parliament's power? Why is Parliament not above the law? It does not take much historical knowledge to understand or find examples of how abuse of power can convert to serious oppression. An unprincipled administration may soon separate the people from their courts and apply dictatorial power, the classic first move of the great dictatorships and of the Stuart kings. They soon limit freedom of speech and allow no criticism, spending the taxes raised for their own purposes. They usually take total power by corrupting the rule of law, delaying and or abolishing the electoral process, etc. All of these things have constantly reoccurred in world history, particularly since the famous jurist Professor A.V. Dicey's time in the early 20th century, when he wrote his altered 8th edition in 1915 of his famous book, The Law of the Constitution. In England, we first had the Civil War of 1642-8, followed by the Glorious Revolution of 1688, in order to ensure that we are governed according to the rule of law and not arbitrary power. It is currently the fashion amongst lawyers and bureaucrats to claim that Parliament is so powerful that it may make or unmake any law it wishes, implying that there are no limits to its power, much in the same way as the Stuart kings claimed for themselves. Further, it is believed that no Parliament may bind its successors, i.e. pass a law which cannot be repealed by a future Parliament. The latter is something of a conundrum, in that it's obvious that if Parliament had total power, it could lay down any law, saying it is to last forever, and place a clause within it to make it irrepealable and binding upon its successors. On the other hand, the law that contained such a clause would only be as binding in power as a power that made it. The words of the statute created by Parliament, and so it is held for a future Parliament being of equal power to its predecessors, may repeal any law. Professor Dicey put this well in his book, The Law of the Constitution. All this is only doctrine. It is the courts who actually determine the application of the law. Judges are, of course, restricted to applying the law as nearly as possible to the written word and guided by case law. They do not and should not have unfettered or political discretion. This ensures the independence from political interference of the judiciary and, above all, the rule of law. Professor Dicey and many others failed to take into account the oath of office as contractual limitations upon the individuals and collectively on the power of Parliament. His book has been accepted as standard constitutional work, and lawyers often refer to themselves as being Diceian. Dicey made this quote about the power of Parliament. The principle of parliamentary sovereignty means neither more nor less than this, namely, that Parliament, thus defined, the Crown in Parliament, has, under the English Constitution, the right to make or unmake any law whatever, and further, that no personal body is recognised by the law of England as having a right to override or set aside the legislation of Parliament. At no time may anybody legally break, ignore, or set aside existing law, even when sitting in Parliament. While this is generally true, it is always within the power of a jury to acquit. A fine example of the power of the common law to override and control statute, and the courts are able to issue their writs. Parliament is said to be free to repeal any law that it makes. It may repeal law that is no longer requires, but it must at all times abide by the letter of the law that is in the statute book and the Constitution. Parliament is not entitled to make law which is deliberately conflicting or in disregard of existing law, and definitely not to make law in contravention of the Bill of Rights. Parliamentarians have no power or right to act illegally in order to create an Act of Parliament. There can be no right to renege upon the oath of office. Yes, there is freedom of speech, enshrined in the Constitution by the Bill of Rights, and the power of repeal, but everyone is subject at all times to the rule of law. There can be no lawful perjury. No prerogative, no party politics or judicial policy should ever override the rule of law. Law that is made contrary to the Constitution is a nullity, and the courts are lawfully obliged to say so in their judgments. A breach of constitutional principle is a breach of oath, individually or collectively. A breach of oath is a perjury, which in turn is a failure of duty and therefore misfeasance in public office, a common law offence. Law that is contrary to the Bill of Rights is technically void, for the courts are duty-bound to obey the words of the law and uphold the Bill of Rights for all time. All of this is constitutional law, and they all have sworn to uphold it. The Bill of Rights is an antecedent to the vast bulk of legislation and is considered a grundnorm or a legal foundation for its part of the Constitution. Contempt of statute is a very serious offence. Dicey's famous definition fails to recognise the boundary to legitimate power. The quote would be better stated if it recognised that Parliament may never put itself above the law or beyond duty. Parliament may make and unmake any law, but it never has legitimacy to ignore or break the existing law or constitution agreed and imposed by oath. This may well seem only a slight adjustment, but the ramifications are extensive. It ensures repeal as well as enactment. It ensures that the interaction of the law and of the burden upon the subject to obey the law must be understood. Ignorance of the law is no excuse for anybody. Parliamentarians are thereby obliged to better understand the implications of the laws that they make. The court are bound by law to uphold the rights of the subjects by overriding the statute if the constitution is in any way infringed. It is no coincidence that the statute book of 1920s ran to approximately 500 pages, whereas today it is 11,000. Parliament has entirely misconstrued its constitutionally limited power, believing it to be a power above and not restricted by the rule of its own law. There are three basic limitations to the power of Parliament: the law, public compliance, constitutional duty, including the common law and custom. The law, all the laws are made to be obeyed by everyone at all times. It is said that the law is of constant and lasting force and no man is above the law. These are fundamental principles of the Constitution which without anarchy would reign. The statute law is composed of the written words recording in Chancery. Parliament has a duty to understand the implication of the law, both statute and common, and the custom. No power is recognised that can overcome this. Vitally, they have independence within these boundaries to make judgments, to define and to clarify the law. So that's it, and then it goes on to the parliamentary oath, the Privy Councillor's oath, the constitutional rights guaranteed in perpetuity by the settlement of the Glorious Revolution. There's ever such a lot in here, there's so much in here that I get lost. So I hope you've enjoyed that reading, and I'll do some more reading another time. The pages aren't in order either. It seems there are pages missing. It's like a proof, or I don't know what you call that. A draft. Okay, thank you for listening. You can tune in to more at we've got a Patreon account for supporting our work, which thank you to our patrons that are on there. Without you, our studies and our admin wouldn't be possible, and we're also creating a lot of resources to describe some of these principles in a nutshell. Under the invocation of Article 61 of the Magna Carta, having that been invoked, and this idea of jury trials and illegal acts and statutes being null and void, and the government acting ultra vires and without lawful authority for a long time, since at least 2001, when Article 61 was invoked, because the rule of law is being broken. So according to that, the government are definitely committing treason, or have been, and therefore they can't be operating lawfully, and they're not within their oaths. That's the thinking anyway. So the fact that Article 61 was invoked means it's the constitutional duty of everyone to stand under it, because ultimately we need to redress the state of play. So you can't really, according to that, sort of allow, people that have already done so much damage to keep running the show or the country, if you like. Really, we're in a state of what's called lawful rebellion, and that's fine. That's just, we don't have to comply with what we feel is morally wrong or corrupted. But it obviously is power in numbers. So if you would like to join our website, it's www.commonlawassent.com, and we have a Patreon account which has a lot more videos and audios. As soon as I start making an audio or a video, and they often can be quite long like this one, and then I sort of go into more depth, and as I become accustomed to what it is that I'm reading myself, I might be able to present this in different ways that makes it simpler. So anyway, that's patreon.com/common law assent, and our Facebook group is Common Law Assent as well. The URL is facebook.com/groups/the real practical law for dissent. Okay. That's really wonderful. Thank you for listening, and I hope you have a lovely week wherever you are within your week.